But this case has went the way of a political election in terms of its discussion. And it doesn't have to be like that. We can and should discuss this case from as many sides as possible. And if the prosecution was perfect and infallible, how do you explain this? I had a couple of very interesting, thought-provoking comments on my last video, essentially saying my take on the DNA was wrong. The prosecution has more than enough evidence to convict, while at the same time the prosecution is making its case just a little bit weaker. So welcome to the point. Let's get to it.
Copyright disclaimer under Section 107 of the Copyright Act 1976. Allowance is made for fair use for purposes such as criticism, comment, news reporting, scholarship, and research. Fair use is a use permitted by copyright statute that might otherwise be infringing. Nonprofit, educational, or personal use tips the balance in favor of fair use.
Everything said here is alleged. Please do your own research and form your own opinion, and let me know that opinion because this is an open discussion channel. Like these comments, for example. Just skin cells, well, that defeats your subsequent argument of there being no contact. You wear rose-colored glasses without explaining how the DNA was left behind, touching an object, touching a victim, without there being any contact. The 3 other DNA weren't eligible for CODIS, which means they weren't in an area consistent with where the perpetrator was. The one on the glove was found outside later in the week after a sweep was already done. The other 2 were likely found in an area of the house they know wasn't entered by the perpetrator, or in a form they know wasn't from the perpetrator like bodily fluids, since no assay took place. The government has very strict guidelines for what can be ran through CODIS. They won't waste resources on DNA that doesn't meet the criteria. And we're fair on this channel, so if more fair coverage on this story and others is something you prefer, subscribe to this channel and hit that like button down below. Because in some ways they're both right. First, to the anonymous person in the back of the room. You are partially correct. One way skin cells end up on an object is through contact. But there's more. And this is why it's important to be fair and impartial. Ask yourself what other ways skin cells can end up on an object. Another way this can happen is simply by you walking by the object and never having touched it. Or you happen to handle an object and another object came in contact with the object you just handled and now your skin cells are on that object that you never touched. As a matter of fact, in 2023, the Innocence Project said since 1989, they found 575 cases of wrongful convictions tied to skin cell transfer. The most notable of those cases to me is the Lucas Anderson story, where he was charged for a passing at a time when he was either in or coming out of the hospital. And you don't have to take my word for it, and I strongly encourage you not to, but go read this case for yourself. It's estimated that we lose almost 5 billion skin cells a day. So you can search online for a published and peer-reviewed study proving your DNA may be on an object you never came in contact with. And after you look that stuff up, come back to me and tell me what you found out. Now, if you reach the same conclusion you did before, then fine, that's fair, okay. But I'm certainly not wearing rose-colored glasses here. In fact, my initial reading on this case was to validate his guilt, since the investigation was handled so abnormally secretive in my own unprofessional opinion. And that's why I came to the conclusion that I see holes right now. That's why I've publicly said if I was a juror on this case, these are the questions I would need answered at trial. And let's be fair with the unidentified male DNA. I can agree that that black glove found outside the home about a week later from the actual incident that was on top of the snow probably has nothing to do with this crime. And I think the vast majority of y'all may agree with me, since it wasn't snowing the night of the incident. I also think that that was the same glove the host of the interview room found when he did an on-the-scene investigation and pointed that out during one of his videos. Now, I don't know that to be a fact, I'm just making a guess here. And yes, if DNA meets certain disqualifiers, it can't be tested in CODIS. Like it's a different type of DNA. It's found in an area they believe not to be tied to the crime. Or it's greatly degraded and known to be significantly older than when the crime took place. But even knowing all that, I still have holes. Number one, they didn't find any DNA tying him to the home. He's tied to a sheath found in the home, but that sheath is a movable object. And to our knowledge, nothing places him inside the home. So you're just blanket putting trust into Bill Thompson? The same person who's lost numerous arguments at these hearings? Not to mention it said that Bryan Kohberger purchased some sort of DNA-proof Dickies suit and had a kit. So how do we actually know he didn't go to other areas of the home? Or how do we know the suspect didn't go to other areas of the home? Now, if we assume Dylan Mortensen and Bethany Funke are innocent until proven guilty, which we do on this channel, the same way we view Bryan Kohberger, then I can buy an argument saying that DNA found inside the home was found inside one of their rooms. And since they're both alive and well, we can assume the suspect didn't go into those rooms while they were there. But beyond that, you're simply rolling the dice in my own unprofessional opinion. As I've said before, the prosecution doesn't have to prove its case beyond a reasonable doubt to the police. They have to prove this to a jury. And the justification of it simply doesn't exist, Judge. Doesn't fly with me. It's probably not going to fly with the jury, and it shouldn't fly with you. Cases are supposed to be prepared to prove beyond a reasonable doubt. And I am willing to admit that the state does have more evidence, it's just sealed right now. It's just my personal belief that it's mostly circumstantial, which would then mean if that's true, the prosecution would need an airtight story with no holes. And based off these hearings, are all the people who see guilt willing to acknowledge that the prosecution's fallen short in providing valid counter-arguments to these holes? Now, Steve Gonzalez was right. Things have changed. People aren't just blanket believing what a prosecutor says anymore. The information age has shined a light into the issues with a lot of these investigations. Look back at the previously mentioned Lucas Anderson case. Look at what Karen Reed's going through. Just because the prosecutor says so doesn't make it always right. And when the defense said they had no connection to the home, referring to the lack of physical evidence made available to them, what did we hear the prosecution say? All I heard was crickets. But we can waste multiple months arguing over this IGG nonsense. Because you don't want people to allegedly find out that type of evidence gathering can be considered unconstitutional, or the certain ways it's used is unconstitutional, which is just my speculation at the end of the day and the subject for a whole nother video. But not making an effort to identify that unidentified male DNA is a problem for the prosecution. I don't care what anybody else says. It will be a problem in court, especially if they can't provide a valid reason why they didn't identify it. Now, I don't recall the prosecution saying that DNA was old, it was a different type, or not located in the area of the crime when this stuff came up at one of those hearings. I heard it simply doesn't exist, Judge. Now, if I heard that wrong and I'm wrong, please correct me down below because this is an open discussion channel. But only two groups of people on this earth have all the pieces and all the information. That's the prosecution and the defense. And the defense has evidence too that not a lot of people are talking about. But this case has went the way of a political election in terms of its discussion. And it doesn't have to be like that. We can and should discuss this case from as many sides as possible. And if the prosecution was perfect and infallible, how do you explain this? In her defense against the DP, Kohberger's defense argued that the U.S. legal precedent does not allow prosecutors to double down on a double count and an aggravating circumstance when the two connected crimes are burglary and passing. A burglary charge, defined in Idaho law as illegally entering a premise with the intent to commit theft or felony, is already rooted in the occurrence of another crime, the defense said. Therefore, that same crime, in the case of passing, cannot also be the basis of an aggravating factor where burglary is the only other charge Attorney J. Loxton wrote. Under Idaho law, a felony passing charge cannot be based on a burglary whose sole purpose is passing, the defense said. In turn, prosecutors revised their intention to seek the DP, citing the other four aggravating factors they previously alleged. Under Idaho law, a jury only needs to find one aggravating factor in the case, including that there was more than one passing to reach a DP sentence. And that was the aggravating factor I said didn't make sense to me very early on. And of course I'm not always right, so maybe it was just a lucky guess. They still have four other aggravating factors that they're wanting to use in this particular trial, and we'll see how those hold up after this next hearing. But maybe I'm wrong in this video too. Maybe you'll let me know down in the comments below. Y'all be safe now.